inviting me. It's an honor to be here and speak to all of you and to be in such distinguished company as those who've given this lecture in the past. And also Kathy Sharkey this year. Later this year, I guess. So, as Stephen said, this could be considered, I have a book on tort law. And one reason I asked if you have questions, do feel free to interrupt, is because I worry as I start unspooling a 311-page book that we could get into abstractions that aren't going to be immediately apparent to you, partly because there are differences in American and Canadian approaches to tort and tort theory, and I'm battling a view that's very prominent in American law, which is the economic view, and I think not very influential in Canada. And so in the United States, my engagement with Canadian views is regarded as something of a sideshow, but we'll see as we go. I hope that's not a general American commentary on Canada. That was not my intent. So one of the features of tort law in our time is that people who teach and write about it can't seem to agree on what the subject is. There's a kind of version of Augustine's predicament about time and Hart's predicament about the concept of law, where Hart said, well, I know what law is unless you ask me, and then I can't really tell you. And there's a view that the tort is suffering from this problem, at least now. Although if you look at the American Academy, Oliver Wendell Holmes, who is probably the most important figure in the history of American, well, maybe American law, but American tort law, at the beginning of his career, announced that tort was not a proper subject for a case book or a horn book. It wasn't really a true subject. He changed his mind 2 years later and wrote very important stuff on tort law. But a contemporary version of this debate goes, Prosser, who was the most influential tort scholar of the sort of mid-20th century in the United States, said, well, what's torts? There's a definition, civil wrongs not originating in contract. And he said, that's fine, but it doesn't provide any guidance to anyone who wants to know, should I do something or not do something, who's not a lawyer. And so he offered as a summary that torts basically concerned with unreasonable interferences with other people's interests in some way. And John Goldberg and Ben Zapersky, responding to that, object that it really fits everything into the mold of nuisance law. And when you consider the line economics approach to torts in the United States, first it conceives of torts as a law of accidents and treats the intentional torts as kind of a historical vestige. They're like an appendix. They're left over, but they aren't particularly significant to the subject or to understanding it. And then they conceive of the tort system as a kind of shadow price system. And it's about the costs of accidents. And that's a very different matter from what almost any other group of scholars think. So my pitch here, I guess it's for a third theory, is that tort should be thought of as a matter of basic justice. And so what do I mean by that? Well, way back when, and this actually comes up sometimes in American case law because American states, all 50 of them, have what are called reception statutes. And reception statutes basically say, we need to get the law from somewhere, because we're just starting as a state or as a nation, but tort is state law, common law. So we're receiving the law of England as it exists at this moment. Or in California, California actually took the law of New York and it set up its legal system around 1870. And courts will actually sometimes refer back to Koch and Blackstone. The Oregon Supreme Court has in trying to figure out whether or not you can abrogate a right in tort and replace it, either just get rid of it, or can you replace it with an administrative scheme. And Koch and Blackstone presented tort as being kind of co-equal with constitutional law, which is not the way many American public law scholars think of this these days. The idea being that public law, constitutional law, secures people against abuses of power and interferences that are unwarranted by the government. And tort law does that with respect to relations among persons in civil society. So for whatever reason, crime doesn't show up in this story. And I want to revive this view in a certain sense. And the way to think about it is, so I'm challenging a view you don't get very much of in Canada, the economic view, which conceives of tort as a set of prices. And when you have that view, tort is resolutely forward-looking. Okay? The key to accident law is the search for the cheapest cost avoider. And the cheapest cost avoider is a party who can avoid an accident at the lowest cost. And when you're confronting a liability question, you look for the cheapest cost avoider. And that means you're not looking backward at who did what to whom. That's a proxy question for figuring out who should bear this cost, because imposing the cost on this party will reduce accident costs to an efficient level going forward. And the efficient level point is key, because since we're dealing with accidents and because it's an economic conception, basically what we're talking about is trading off resource uses. There's the resources consumed by the fact that accidents harm and kill people, and then there are the resources consumed by avoiding them, and we want to minimize the combined cost of those so as to maximize wealth, so as to enable us to have the most resources for pursuing human welfare generally. The corrective justice and civil recourse responses to this tend to fix first on tort law's remedial structure. And what they argue, and Ernie Weinreb has been very influential here and very powerful, and he teaches at Toronto, is that this misconceives the remedial structure of tort law, because the remedial structure of tort law is a backward-looking enterprise seeking to answer the question, who wronged whom? And I think it's a powerful critique, and it ends up saying that for the economic analysis of law, the structure of an ordinary tort lawsuit and the content of all kinds of standard tort doctrines like duty and breach have to be understood as proxies for something else, so that it's a kind of systemic misrepresentation of what's really going on, whereas what's really going on is the balancing of interests in an appropriately economic fashion. Related views assert that it's the power of recourse, seems to me, which is the power of wronged victims to bring suit and seek redress for harm. That's central to the subject. This critique of economic analysis seems to me correct in both aspects. That is, there is a duty of repair that's fundamental to tort law. It's a sort of distinctive way of enforcing rights, and tortious wrongs do create powers of recourse in the hands of victims in the way our legal systems operate. But it also concedes the sort of primary norms of tort law to economics, and that's what concerns me. These views have relatively less to say about the primary norms of tort law, except to emphasize that they're wrongs as opposed to prices. And what I want to say is that the primary norms are the center of the subject, because it's those things that trigger the applicability, the violation of those norms, that bring into play the secondary norms of repair and recourse. And we ought to put them at the center of our understanding of tort theory. So, my argument is that the primary norms of tort address a fundamental aspect of social life. And this is an aspect that's not hardly unique to me. For example, again, taking Ernie Weinreb as a important figure here, and he certainly is, he speaks of the unity of doing and suffering, okay? And think of that generally as the way our social world is constructed. It's the case that sometimes one person's elbow is going to be in another person's face, and there just isn't any way around that, that our interactions threaten to impair and interfere with each other in certain ways. And that the obligations that we have not to interfere with and impair other people in certain ways are really the domain of tort law and a common law system. Contracts concerned with obligations we acquire by entering into agreements. Property is concerned with obligations we acquire by obtaining ownership or an interest in certain kinds of external objects, so our obligations in property are mediated by the external objects through which we're related. Tort law is just about obligations we have to other people, essentially qua persons, not to impair and interfere with their essential interests in certain ways. And the core of tort law, which in the United States is really physical harm, then radiating out to psychological harm, so as you could say in negligence law, you have a duty of reasonable care. California, when it incorporated New York law into a statute, included a provision saying everyone knows everyone else a duty of ordinary care. That's a presumption. We probably now say reasonable care, and it's defeasible, but the idea is it's a basic demand of law, and behind that I think of morality, that we have to attend to not interfering with, do no harm in a certain sense. And next, I think this has content that leads to a different view from the economic view. And though it's mostly on a topic that I think is different from the topic of the corrective justice and civil recourse, probably to a different view, because in some ways it does have something in common with Holmes's view. So what I think is at the center of this is, first, there's something to the idea of reasonableness, that reasonableness is a distinctive norm. And it's a way to see this is that in the economic account, reasonableness is rationality in a certain sort of social sense, okay? By that I mean it's collective rationality, not individual rationality. Now, if you take individual persons, reasonableness and rationality are quite different things. Reasonableness is about behaving in a way that takes appropriate account of other person's interests and acting in a way that's justifiable to them, so that if you were to, say, switch positions, you'd be prepared to accept the way you behaved. Rationality is just about pursuing your own interest intelligently and effectively, instrumentally, in the best way you can. There's a Massachusetts case. It's actually an intentional infliction of emotional distress case, one of the earliest in Massachusetts, and maybe the first one in Massachusetts. And what it involved was, it was Aegis versus Howard Johnson. Howard Johnson was a restaurant chain that's defunct, but once was maybe the largest restaurant chain in the United States, and almost certainly in New England. And what happened was, the manager of a restaurant had discovered ongoing theft, and he was sure it was an inside job. So he lined employees up in alphabetical order and just started firing them in alphabetical order in pursuit of somebody saying that, ratting out who did it. And the first person lined up was a waitress whose last name was Aegis, and so she was fired. And the Massachusetts Supreme Court said, that's intentional infliction of emotional distress. Now, I'm going to ignore the details of that doctrine and just put it in reasonableness and rationality terms. There's nothing irrational if you're the manager of the restaurant in trying this tactic. You might think this is going to be effective. Somebody's finally going to knuckle under instead of being, they're going to know, and rather than be fired, they're going to out the thief. So from an individual point of view, it's rational. I think it's canonically unreasonable to fire someone simply to use them as an instrument to figure out if someone else did something wrong. It violates a very fundamental sense of appropriate treatment of other people. So the economic view doesn't say individual rationality, but it says treat tort reasonableness as what one actor would do if they bore all of the affected interests, okay? The problems with that are subtler, but they're real, and it's that we have diverse interests. And it's not really, I think, the way that law goes about this, it doesn't attempt to reconcile those diverse interests by thinking the way an economist does. the way that an economist thinks, at least in theory, is, well, whether or not you should satisfy somebody's interest or preference depends on how much they'd be willing to pay to have that satisfied. That's how a market works. And that's a quintessentially subjective idea of interpersonal comparison. We should compare people's interest in something by measuring the subjective intensity of their preference for something. It really has its roots in utilitarianism. And tort law, I think, operates a different way. It operates by using what are sometimes called normalizing assumptions. And by normalizing assumptions, I think it's judgments of how urgent something is. So in the United States, the law of negligence has to address, I'm sure it does other places too, I just don't know how it does it, children. What standard of care do you impose on children? And the answer is age appropriate for ages about 7 to 14, not capable of negligence under 7, adult after about 14. But there's an exception, which is you're held to an adult standard of care if you're engaging in a adult activity. Now, if you think about that exception, it makes perfect sense if you think in terms of what I'm calling normalizing assumptions. So children have a pretty big stake in engaging in age-appropriate activities. Call it paddle boats instead of power boats. But in our view, they don't have any kind of legitimate interest in operating power boats and cars and other adult activities. And that's really what's being, one of the things that's being underlies the judgment that they're going to be held to an adult standard of care. Another is, well, they create adult risks, whereas childlike activities create lesser risks. But that objective judgment of how important it is that children be able to engage in certain activities is nothing like the judgment of how much would they be willing to pay, okay? And which could lead to absurd hypotheticals about Elon Musk's children and how much they might be willing to pay. But how much they might be willing to pay is just the wrong kind of question. So the argument then is that reasonableness is a fundamentally different thing from rationality. And reasonable care is not the same thing as rational care. And where this, I think, cashes out in tort law is really most clear when you step outside tort law and address certain kinds of regulations. In the United States, environmental regulation and health and safety regulation. The environmental regulation often just uses the term safe, okay? That is something like the amount of toxin or pesticide left on agricultural produce has to be reduced to a level where it's safe. Safe is a term of art. It doesn't mean zero risk. It means so little risk that a reasonable person would disregard it because you think there are so many other risks out there. Why would I worry about that? And the magic number tends to be 1 in a million chance of excess cancer. That's what's safe. But it's not presented as a cost-justified norm. It's presented as the right way to think about acceptable levels of risk from pesticides on food. The OSHA statutes typically require feasible precaution. And feasible precaution is the amount of precaution against harm that an activity can take without jeopardizing the long-run survival of the activity. And economists regard these as irrational measures of precaution because they are presented as more than cost-justified precaution. Cost-justified precaution is marginalist. You add up the costs, you add up the benefits, and you maximize wealth. So $1 less in spending $1 more avoiding an accident isn't worth it if it avoids less than $1's worth of accidents. And that standard seems to me quite correct if you're dealing with just damage to property, which can be a tort subject, and the property is commercial. It's not some heirloom that has a value that escapes markets. Then it seems to me fine to say we should regard it just as an economic resource and treat it as an economic resource and maximize wealth with it. But when you're dealing with persons, the mistake economic analysis makes is treating them purely as resources and not assigning more value to them. And how does this wind up cashing out and lead us to the OSHA and environmental statutory standards? Two things are fundamental. First, from the point of view of economics, costs and benefits are symmetrical. They're just pluses and minuses on the same scale. But there's a thing that's quite, most of us have before we even go to law school, and it's the harm-benefit asymmetry. People respond to harms as asymmetrically worse than benefits. They think it's worse to be harmed in a certain way than it would be to receive the economically equivalent benefit. That kind of asymmetry, we should take more precautions against harm. We have more reasons to avoid harm to ourselves and to others. That's regarded as just essentially irrational from an economic point of view. I think it's actually defensible once you conceive of the matter differently. And the difference in the matter is to conceive of torts as a matter of relations among persons, not as a matter of generating as much wealth or welfare out of various activities as possible. And so it's a matter of what we owe to each other in the way of obligations not to interfere with and impair each other. And harms are asymmetrically worse because they impair fundamental capacities we have as persons. So the core for American tort law, and I don't think atypically of, say, negligence law, is physical harm. And the core of physical harm is damage to a person that deprives them of a normal bodily capacity. So you've got a broken arm or broken leg, you can't do something that you would otherwise be able to do. If you're afflicted with certain kinds of disease, you're comparably impaired. So harm in this sense is, what you're impaired is the ability to exercise your will, to affect the things you want to affect in the world. And benefits are sometimes, but not always, comparably urgent. In general, it's true that whether or not a benefit is beneficial to someone depends upon their particular life plans and aspirations. So, for example, being a mathematical genius, certainly helpful if you want to do math, but for someone who doesn't want to do math, it's kind of useless. I think that's true of lots of things. You could take it to be true of. It happens to be the case that quarterbacks in football have extraordinary visual spatial processing skills, okay? Probably way above anybody in this room. And that's necessary because playing quarterback in football isn't just about having a strong arm. You have to process a huge amount of information in a very short span of time because you've only got a few seconds to get rid of the ball as a quarterback. And it turns out most of us get cognitively overwhelmed, but not elite quarterbacks. That's a very specialized skill. It's a very specialized benefit. It's essential if you want to play at the most elite level, but the rest of us who don't have that don't even notice we're missing anything. So there is an asymmetry between harm and benefit, and the asymmetry justifies more in the way of precaution than cost-justified precaution. This is particularly true when you think of the more severe harm is because tort's a reparation system. And when harms aren't so severe, if it's just destruction of commercial property, they're repairable. The only thing that's not recoverable is time. But you can repair damaged commercial property because it's fungible with other things at some rate of exchange, so it's got a price, and you just get the price as the damages, and reparation works. But many physical harms, perhaps most physical harms, aren't fully repairable. And what you see in tort law is, well, the extreme case of this is premature death. There's no amount of reparation that's going to take someone who's been killed and put them back on the indifference curve that they were before they were dead. And in tort, that's recognized by the fact that damages for wrongful death never include damages for the victim for the value of the life they've lost. There are 2 or 3 American jurisdictions that try to work in enjoyment of life damages, but it's very rare. And what that means, if you think of it from an economic point of view, the tort system is imperfect deterrence mechanisms because it can't price the most important kind of harm. I think what it means from a corrective justice position is, well, you can't repair the biggest kinds of harms. And I think that's why you wind up being led to regulatory standards as not just a separate thing, but the law of torts is intrinsically incomplete insofar as its topic is harm, because it can't really respond to the most severe harms. And that's why standards like the one found in environmental law and in health and safety regulation matter. And it's there that the asymmetry of harm and benefit justifies using standards that are more stringent than cost-benefit analysis. And I think of it as essentially, safety is the first best world, but in our world there are activities we can't give up that you can't make safe in the sense of reducing the risk to the level that everyone would disregard it. Used to be, although it no longer is the case, that the cases that litigated this out were cases involving oil, among other things. And it was just unthinkable in the 1970s that you could give up an oil economy. We'd like to think now it's not unthinkable because we need to give it up. But the idea is no matter what side effects it has, you can't insist upon a level of safety that's such that it drives the activity out of business. Or if you ever do Boomer v. Atlantic Cement in Canada, a major American nuisance case, the court refuses to enjoin a nuisance that's very clearly a nuisance to the neighbors because the defendant's taking all feasible precaution. It's basically the same standard as the OSHA standard, and still spews cement dust and fine particulate matter out, and we can't give up the cement plant. So that's one place that it cashes out. And the other place that it cashes out, and I will just try to wrap up briefly, is to say the significance of harm makes a place for strict liability, which is anomalous but still exists in our legal systems, I think. And it does so for two reasons, at least. One reason is that harm has significance even when its infliction shouldn't have been avoided. So on a certain view of negligence, there's really nothing left of moral concern when somebody's been careful. Whatever harm happens just falls under, it's like lightning striking. It's just a bad thing, but it has no moral significance. In my view, it still has moral significance even if it shouldn't be avoided, because it's seriously bad for the people who suffer it. So there is a reason to go to strict liability under the right circumstances. And so the question is, what other circumstances? The fundamental thing that I suggest is relevant is if there's some kind of asymmetry of burden and benefit. You tend to think of negligence as applying to activities where everybody roughly benefits from engaging in the activities. Driving would be the classic example. And other things equal, we might as well leave the losses that can't be avoided on whoever suffers it, because we'd just be shifting harms onto people who suffer, who can't avoid inflicting them. Doesn't seem any fairer. But there are circumstances where, in fact, strict liability distributes the benefits across the cost of repairing the harm across those who inflict it, and that's a fairer situation. Last, something that I think may be kind of rare in Canadian law, there's something called enterprise liability in American law. And it actually can be traced all the way back to Holmes, who drew a distinction by saying, the law of torts comes from an old world of nominate individual wrongs, libels, slanders, and the like. Our new law of torts is going to be addressing accidents that are the costs of activities, railroads, manufacturing, that kind of thing. So enterprise liability, which kind of had its heyday in American law, probably the 30s through the 70s, but still exists, is fundamentally a collective form of responsibility. And I want to say this kind of collective form of responsibility, which exists both within tort law but also beyond tort law, does belong inside tort law, even on a view that thinks that it's about responsibilities, not just about social engineering of desirable amounts of welfare in the world, because activities can be a fundamental source of harm in our world. And it's generally a standing possibility to conceive of particular kinds of harms, either as individual wrongs or as costs of activities. And because activities are so prominent in a industrial technological world such as ours, imposing liability on activities, which will mean things like on firms through vicarious liability law, on products liability, probably on a stricter interpretation, but also through alternatives that aren't tort-like, like workers' compensation, nuclear accident schemes, maybe even the New Zealand accident scheme. That too makes sense because we live in such different social conditions from the conditions that we inherited the common law of torts from. Thank you.